Welcome everyone to our panel on Delaware and Texas, the future of corporate law and business courts. My name is Emil Ark. I'm a partner at Hogan Lovells in New York and also a member of the executive committee of the Society's Corporations and Securities Group. We're here today to explore the topic of Delaware and Texas. The status quo shows signs of disturbance in corporate law. Some Fortune 500 companies have reincorporated outside of Delaware or have contemplated doing so. Meanwhile, Texas is attracting companies by promoting its pro-job and pro-business environment as a strategy that includes changes in the Texas Business Court. So we're going to take a look at the future and see what that means for corporate law. I'm sure all the lawyers in the room are also thinking about, oh my God, I've been giving Delaware opinions for all these years. Am I now going to be able to give Texas opinions if my firm doesn't have an office there? There are also practical aspects to all of this. Will Delaware remain the preferred home for American corporations, or are we witnessing the rise of other corporate capitals, including, of course, Texas? So here to introduce the panelists who will be discussing all of this and to serve as our moderator is Judge James Ho of the United States Court of Appeals for the Fifth Circuit. Before taking the bench in 2018, Judge Ho was a partner and co-chair of the National Appellate and Constitutional Law Practice Group at Gibson Dunn. Judge Ho was an appellate litigator for over a decade, including 3 years as Solicitor General of Texas. Judge Ho has also served in all three branches of the federal government. On the Senate Judiciary Committee, he served as Chief Counsel of the Subcommittee on the Constitution and Immigration under Senator John Cornyn. At the Justice Department, he served as Special Assistant to the Assistant Attorney General for Civil Rights and as an attorney advisor at the Office of Legal Counsel. He clerked for Judge Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit and Justice Clarence Thomas of the U.S. Supreme Court. In addition, Judge Ho has served as an adjunct professor of law at the University of Texas School of Law, where he taught seminars on U.S. Supreme Court litigation and religious liberty. So with that, I'll turn it over to Judge Ho. Thank you.
So apologies for late start. Because of that, I'm actually going to just have a brief introduction so we can get right into our panelists. But I am very pleased to be here from the great state of Texas. As a Texan, we pride ourselves on having some really great rivalries. The Texas Longhorns versus the Oklahoma Sooners, the Dallas Cowboys versus the Washington Redskins. Compared to those brutal gridiron matchups, the competition between the Delaware corporate bar and the Texas business courts might seem kind of mild and nerdy by comparison, but we'll see if our panelists today can rise to that occasion. We will begin with Rudy Koch from the Wilmington, Delaware law firm of Richards, Layton, and Finger. He'll be followed by Judge April Farris of the Texas 15th Court of Appeals, which is the newest appellate court in Texas with exclusive jurisdiction over the Texas business courts. Next will be Will Thompson from Lehotsky, Keller, Cohn in Austin, Texas. He'll be followed by Jeff Brown, Chief Legal Officer of the Texas Stock Exchange. And rounding out our panel will be Anthony Rickey of Margrave Law in Wilmington, Delaware. Now, I've asked each of the panelists to give some opening remarks. Then I'll invite the panelists to respond or question or engage with one another as they see fit before opening it up to hopefully some questions from the audience, any that you all may have. So with that, we'll begin with Rudy.
And thank you for the introduction, Judge Ho. appreciate the opportunity to address this group and also to be on a panel with such distinguished panelists. I will obviously approach this panel through the lens of someone who spends most of his time litigating in the Delaware Court of Chancery and the Delaware Supreme Court. Specialized business courts can help states create an attractive and inviting business environment broadly in two ways. So the first way is a good business court can allow companies to that do business in a particular state to undertake commercial relationships with some level of comfort that if problems arise, there's going to be a court that can efficiently and promptly hear their disputes. The second is that business courts can make a state more attractive as a place to incorporate your business or to form a limited liability company or some other type of alternative entity. In the first sense, Texas has recently improved the business environment through, among other things, as you'll hear today, changes to the trial court and the addition of things like the Texas Stock Exchange. And obviously, I commend Texas for that. I think that's a public good, and I think that's great that they've done that. In the second sense, however, although Texas has simultaneously attempted to attract companies to incorporate there, I think Delaware will continue to dominate for corporate charters. And that's really what I want to focus on today. There is a reason that Delaware still is home to 65% of the Fortune 500 and has more citizens that are entities than are people. And I want to begin today by describing four of the many pillars that support the extraordinary foundation of Delaware corporate franchise, each of which plays an important role in providing for the balance of stability, flexibility, and fairness that's necessary for effective and efficient corporate decision-making. Then I'll explain a little bit about the recent criticism, some of which is fair, others that's not fair, explain how we have responded, and then I'll tell you why I think we're going to dominate for the foreseeable future. So the first pillar I want to talk about is political stability. There is a lot of effort these days in this country to put everything into a red state or blue state sort of box or paradigm. And the opponents to Delaware tend to say, look, Delaware is a blue state. Why don't you incorporate in a more business-friendly state like Texas, which is a red state? When it comes to the corporate franchise, I think Delaware is possibly the only state that defies that paradigm completely. Delaware is a very small state. The corporate franchise makes up an enormous portion of our state's budget. It is literally our leading industry. Our second industry is chickens. I don't think it's going to surprise anyone to hear me say that there is not a lot else going on in my state, and I think that's something that is really good for corporate law. The corporate franchise is always going to be vitally important to the state, and that's why, for example, when we recently passed corporate amendments, our Senate voted 20-0. So 100% bipartisan in favor of those amendments. So simply put, Delaware is largely immune from the typical political pressure that we see, particularly national politics, when it comes to its corporation law. Its political interests are aligned with maintaining the corporate franchise. And this political stability is also reflected in two important ways in the Delaware Constitution itself. So first, our Constitution precludes our legislature from altering any individual corporate charter and also requires 2/3 vote of each of our legislative houses to amend our general corporation law. And if you contrast that with other states, including, for example, Texas, where simple majority rules, you can see how national politics can get grafted onto the corporate law. In addition, our judiciary has long maintained a requirement of political balance, and that is actually set forth in our Constitution. So no more than a bare majority of any court can be affiliated with a single political party. Unlike most states, you also cannot get politically hometowned in the state of Delaware. We don't have a lot of companies who are physically present in our state, and we certainly don't have any company or even any industry, and I'll dig Nevada on this one, that is strategically as vital to the state as our corporate franchise is. So the second pillar is our balanced and enabling general corporation law. So I'll refer to it as the DGCL. It is crafted to be flexible statute. One size does not fit all. That ought to resonate particularly with this crowd. Our code is also regularly updated with the advice of corporate experts. The Delaware General Assembly meets annually. Contrast that with most states, including Texas, where the legislatures usually meet biannually. And when we need to act quickly in Delaware, because we're a small state and because it's so important when it comes to our corporate franchise, we can act very quickly. Because our statute's enabling, there are a lot of things that you can do in Delaware that folks don't probably even realize you can do. And one example I was thinking about before I came up here is Texas recently amended its corporate statute, and there's one amendment that I actually like. It's a threshold for derivative standing. Now, it's 3% in Texas. I can see why some investors might think that's too high or it's not investor friendly, but I think for some companies that might be a good option. In Delaware, we have a statute, a public benefit corporation statute. OpenAI actually is going to become a Delaware public benefit company. And that itself also has the option to opt in to a threshold for derivative cases. So I believe, and I'm happy to advise folks on this, that in Delaware, if you wanted to, you could put a threshold into your charter because the DGCL is enabling and it's not prohibited and it's not void for public policy. Third pillar is our established corporate infrastructure that we have. So our government agencies, particularly our Secretary of State, the Division of Corporations, are amazingly service-oriented towards our corporate citizens. Unlike in most states, that's our leading function effectively for our Secretary of State. So the Division of Corporations reviews filings only for form. They're not going to interfere with any of your filings. Your filings can be pre-cleared. That means you know exactly what is going to be approved before you hand it to the Secretary of State. The filings can also be processed on a guaranteed basis in as little as 30 minutes. That's crucially important, particularly when you're doing M&A transactions. We also have a sophisticated bar. So, for example, my firm has been advising we just had our 125th year anniversary, and that's really part of what we would call the network benefits. The fact that so many companies are incorporated in Delaware is a benefit in and of itself. And the reason is we test more corporate scenarios than any other state. We have more case law and guidance, so transactional lawyers and folks like myself can guide companies on what works and what doesn't work. The fourth pillar, and this is the one I think we'll probably hear a little bit more about today compared to Texas, is our expert court system. So the Court of Chancery is sort of known as our crown jewel. It's been recognized as the #1 business court in the country for a long time. Very sophisticated, very prepared judges who understand corporate law, and they stay abreast of changes to corporate law. They go to conferences, they talk to businesses, they're in the sauce. 12-year terms by the Constitution. So that also leads to stability of the courts. 100 years of precedent, not just decisional precedent. So precedent on how do I get an injunction? What type of confidentiality agreement can I get? How do I get a case expedited? No jury trials, guaranteed. Other states, their constitutions say you have a right to jury trial. So even if they say maybe we're going to have a business court, it's not clear that works. No punitive damages, no pre-suit discovery. Dismissals are with prejudice. You cannot replead. Importantly, litigants get a guaranteed right of appeal to the Delaware Supreme Court, which is the most sophisticated Supreme Court in the country when it comes to business matters. The Delaware courts also move quicker than any other court in the country. 28% of the docket is expedited. They move at the speed of business. I have back-to-back expedited trials after this. I've got a trial in a week from Monday, and then I got a trial 3 weeks after that. Both cases would have gone soup to nuts in under 2 months, and the court will render a decision within a week of trial. The other thing that people don't think about is when it comes to the court system, if you incorporate in a state, you are generally subject to jurisdiction in that state. So there's no place you would rather be than the Delaware District Court if you're defending your patents. Our complex commercial division of our Superior Court, best place to hear a contract dispute. Our bankruptcy court, very sophisticated on Chapter 11s. All right, so I gave you a little bit of a pitch. I know it sounds amazing. So why are we here? Why are companies considering their options? Why is the press or the fake news putting sexy headlines out there about Dexit? So here's kind of, I think, what happened, okay? We had some recent challenges are centering around the perception that there's an increasing litigation burden in Delaware and that the Court of Chancery has become a little bit less predictable because of that and a little bit less pro-management. And look, I think some of that criticism is fair, But here's what happened in a large part, and Anthony will diagnose this maybe a little differently at the end. But we established certain doctrines. They arose in a squeeze-out merger context with respect to controlling stockholders that were enabled to give you a pathway to get to the business judgment rule. Over time, we expanded those so that they would apply anytime a controller was getting a non-ratable benefit, so anything special that was going to a controller, and they morphed from sort of safety valves into rules that you had to follow. And if you didn't follow the rules, you were going to get heightened scrutiny over your transactions. And that really culminated in the Musk compensation case. I think that's an outlier, but I think that's how the court ultimately got there. Full disclosure, I was hired after the trial decision by Tesla. I represent them on the appeal, so I can only say limited things about it. The Delaware Supreme Court heard argument, I think 2 weeks ago. I would encourage everyone to listen to that argument. You can watch a video. We record the Delaware Supreme Court arguments. You will see how very sophisticated that court is. In response to what I'll call doctrinal creep, Delaware has taken several steps to sort of rebalance and go back to basics. So we passed Senate Bill 21 that provides now a clear definition of who is a controlling stockholder, clear statutory safeguards for conflicted transactions, safe harbors that you can afford yourself to, deferring more to independent and disinterested directors, deferring more to stockholders, streamlining certain books and records requests. Now, the statute was drafted in connection with hearing from multiple corporate constituents, but I would note that if the Musk case were filed today, it would be dismissed under the statute on the pleadings. And I would also point out that the plaintiffs' bar, who is a little bit of a problem in Delaware, like lit their hair on fire over the statute, like literally like self-immolated on LinkedIn. And that would be my number one evidence that the statute was directly on the target. So the second thing we did is the Court of Chancery has now gone to a wheel, so sort of random assignments, so that there could be more fairness that people perceive in how cases are being assigned. I think that's important for any business court. And then the other thing that we did is the legislature specifically asked the Corporate Law Council, which is the section of the bar that kind of recommends legislation to the legislature, and the legislature adopts that legislation nearly all of the time, to look into plaintiffs' fees. And that is important. So I commend Texas. You have a 4x basically lodestar cap on plaintiffs' fees for class actions. I think that is a good thing. Mr. Rickey and I will both agree as Delaware lawyers that the fees in Delaware are too high. The difference, I think, between us, as you'll hear today, is I am confident they will be reined in imminently. The Delaware Supreme Court has started to chip away on the fees in the Dell case. They have 2 Tesla appeals where they can further chip away on fees. And the legislature is also separately considering this. So either by the judiciary or by the legislature, I think we'll be moving more towards a sane fee environment. And I think those incentives will really matter to reduce the litigation burden on Delaware companies. So look, let me conclude this way. I'm probably going over. I like a lot of things about what Texas is doing in its general business environment. I like the trial level business court and the intermediate appellate business court. They seem great. The judges seem great as well. Obviously, Texas Stock Exchange, I think that competition is good too, particularly after the recent election in New York. I think Texas Stock Exchange may be doing a little bit better. I don't think that will translate into Texas being able to compete with Delaware for corporate charters. I've seen this play out many times over my career. The structural advantages that I laid out, and I'd love to talk about them for 10 hours if I had 10 hours, but I would bore you to death. They're real and they're powerful. So the improvements Texas are making, I think that's great. I think they'll actually help on the corporate side to kind of push Delaware to do better. I think the competition is healthy. It'll make us stronger. We'll continue to refocus back to bring fairness, efficiency, predictability, as we've always done. But I sincerely believe that Delaware has served corporate America well for a very long time now, and I think we'll continue to do so for a long time to come. And with that, I will hand it over to my friend from Texas.
Well, good afternoon. I am so excited to be here today to tell you a little bit about our new Texas Business Court and also a little bit about my court, the 15th Court of Appeals, that hears the appeals from the Business Court. And I could easily spend an hour and a half on this topic. I could spend longer. But instead, I'm going to give you a very brief 8-minute rundown of 10 things that you should know about the new Texas Business Court. So number one, why did Texas need a business court? Well, Texas is famous for its cowboys, although perhaps not the Dallas Cowboys variety anymore. It's also famous for its oil and its barbecue, but Texas is also becoming famous for being a business superpower. For 20 years in a row, Chief Executive Magazine has named Texas a best state for business. In 2023, the Texas legislature enacted House Bill 19, and this bill was designed to make the Texas judiciary a robust forum for business litigation that truly fits Texas's status as the 8th largest economy in the entire world. Delaware can't beat us on that yet.
Nope.
So that bill created the Texas Business Court, and this was a huge deal for Texas. Since then, companies like Chevron and SpaceX have announced plans to relocate to Texas. The Texas Stock Exchange, that we also call Y'all Street, has been cleared to open in 2026 and has already secured $250 million in capital. So, in other words, big things are happening in Texas, and we needed a court system that was ready to take on those big things. The business court is designed to create a fast track for business cases and to enable those cases to be heard quickly by judges who have special expertise in complex commercial litigation. So, in other words, no more waiting in line behind DWIs and personal injury cases. So, number two, is the business court just a Texan version of the Delaware Court of Chancery? Answer, no. This may be a huge shock to all of y'all, but Texans are very, very proud of our state, and we like to do things our way, the Texan way. For example, my travels outside of Texas have clued me into a very disturbing trend. Hotels in other states have waffles that are shaped like sad little rectangles. Texas hotels know better. Waffles must be shaped like Texas. It is simply how things are done. In the same spirit, Texas went its own way in designing its business court system. The Delaware Court of Chancery was created back in 1792. It has exclusive jurisdiction over all matters and causes in equity, and it also has the power to interpret and enforce Delaware general corporation law. But it generally can't hear garden variety legal claims like breach of contract or fraud for damages where a sufficient remedy can be had by common law or statute. The Texas Business Court is a totally different animal. It is not an exclusive jurisdiction court. It has concurrent jurisdiction with regular Texas trial courts over the claims that the legislature has designed the court to hear. And so these cases can be heard in the business court or they can be heard in Texas trial court. And it's not just limited to equity and corporate governance. So, number three, what kinds of claims can the Texas Business Court hear? Well, it's helpful to think of the entire universe of claims out there and divide them into three boxes. Box number one consists of the stars of the show. These are the claims for which the legislature has explicitly vested the business court with concurrent jurisdiction. The second box are called supplemental jurisdiction claims, or what I like to call tag-along claims. These are going to pop up in the cases where you might see a box one claim. But these are not specifically designed for the business court, and you can only bring them in business court if all of the parties agree and the court agrees that they can be heard there. Otherwise, they have to be filed in regular Texas trial court. And box three are what I call the no way, no how claims. These include personal injury, wrongful death, consumer transactions. The court can't hear these no matter what. So, number four, what is in box one? A lot. So if you want the full list, go check out Texas Government Code Section 25A. I'm just going to give you a very, very general high-level overview. There are lots of carve-outs and exceptions, so don't take my generalizations as the final word. Go look at the statute. But the first category is generally going to consist of corporate governance claims where the amount in controversy exceeds $5 million. This category is going to have your derivative proceedings and your breach of fiduciary duty claims. The second category consists of corporate government actions or corporate governance actions if either party is a publicly traded company, and there's no amount in controversy limit for this category. And the final category has plenty of carve-outs, but it is generally the qualified transaction category. I'll just describe it as most commercial claims where the amount in controversy exceeds $5 million. Parties can also put in their contracts that the business court will have jurisdiction over disputes arising from the agreement, so long as that's not an insurance contract. Now, the legislature recently has expanded the court's jurisdiction to specifically include claims involving trade secrets, intellectual property like pharmaceuticals, biotech products, and bioscience technologies. Also, if you come to business court, you can get TROs, you can get mandamus relief, declaratory relief, and you can also sue to enforce an arbitration agreement. So number 5, juries or bench trials. Texas loves juries. In fact, we're honored to have Chief Justice Jennifer Elrod in our audience here, and she's done just some remarkable scholarly work on juries and why they're important. But we love our juries. Parties are entitled to a jury trial in all cases involving legal rights, but we do allow jury waivers, and the legislature recently passed a law that allows corporate bylaws to waive the right to a jury trial. In the Court of Chancery, it's bench trial only, no jury for you. Number 6, what are the judges like on the Texas Business Court? Well, if you go to the Delaware Court of Chancery, your judge is going to be a governor appointee. If you come to Texas, your judge is also going to be a governor appointee. They're appointed for 2-year terms, unlike in Delaware, which is 12-year terms. But there are some qualifications that make Texas unique. The judges have to have spent 10 years either practicing complex civil business litigation, practicing business transaction law, or serving as a civil judge, or some combination of those. Number 7, what is the appellate process like? In Delaware, appeals go to the Supreme Court of Delaware. In Texas, all business court appeals come to my court, the 15th Court of Appeals. We're a brand new statewide court, intermediate court, and we have exclusive jurisdiction over all of those cases. That's designed to achieve harmony and efficiency. We also hear a few other things like constitutional cases and the administrative docket. And so while there are lots of states out there that have business courts, to my knowledge, no other state but Texas has anything that's quite like the 15th Court of Appeals. Number 8, what kinds of cases are being filed in Texas Business Court? About 30% of the cases are energy industry, another 20% are real estate development, and 10% are financial industry cases. We're also seeing a fair number of healthcare and tech company cases, and the business court actually held its first bench trial this week in an energy case, so we are off to the races on that. Number 9, well, Justice Farris, you've convinced me. How do I get my case to the Texas Business Court? If you have a claim falling within the court's jurisdiction and venue is proper, you can file there as a matter of right. There's also a limited window for moving cases that are filed in other Texas courts to the Texas Business Court. It's important to remember that venue has to be proper, and right now there are only business courts operating in kind of the major metro areas and surrounding counties. Also, last session, the legislature passed HB 40, which allows parties to amend their governing documents to designate venue for business court matters involving derivative proceedings, governance, and fiduciary duty claims, and other actions arising out of the Texas Business Organizations Code. Number 10, well, is this enough for Texas to take Delaware's crown as king of all things corporate? I would say it's too soon to say, but I think what Texas has done is create the groundwork to make that a real possibility. But it's ultimately going to come down to the people that Governor Abbott has appointed to the business court and whether they've earned the public's trust. I think the elephant in the room is the Tornetta decision that invalidated the Musk pay package. And I won't comment on whether that decision was right or wrong, but I think what was shocking about it is how it was reasoned. The opinion said this decision dares to boldly go where no man has gone before, or at least where no Delaware court has tread. Now, typically, courts don't like being called innovators. In fact, some of us see it as almost an insult. We see ourselves as following precedent and sticking to well-trodden paths. So when you have a court announcing that it's going to dare to go boldly where it hasn't gone before, I kind of get a pit in my stomach. The way, like, when you see like a Texas good old boy say, "Hold my beverage and watch this." You can, when you see those words, whatever comes next may not be good. And in Texas, you can only hope that it doesn't involve rattlesnakes or gators. But at the end of the day, it's up to the Texas Business Court to earn the public's trust, and that's what matters most.
Well, thank you, Justice Farris and Rudy, for laying those out. I think I'm going to try to zoom out a little bit and talk about the competition between the states here. So a lot of us in this room probably believe that competition between companies is good and tends to produce better results. It makes us more efficient. And I think the same thing is playing out here in the competition between Delaware, Texas, Nevada, and other states. So there are a couple of kind of avenues in which this competition can take place. One that Rudy talked a lot about was whether states might want to whether companies might want to reincorporate in Texas instead of Delaware. I know from firsthand experience that sophisticated companies are seeking advice on that. I think it's too soon to say how many of them will follow through. But companies we all know and love are strongly considering whether they need to be somewhere else. The other avenue that comes to mind is whether it's just better to do business in Texas, not just be incorporated there, but actually have your operations there, have a principal place of business, have your main litigation there because that's where you're from. And I do think the Texas Business Court, regardless of how much it succeeds on that first front, is already succeeding on that second front. A lot of companies that already do business in Texas have been very interested in the business court and its reforms. And the differences, if you practice in Texas trial courts, are pretty stark. Not to cast any aspersions anywhere, but if you show up in certain Texas trial courts in some of our major metropolitan areas that aren't the business courts, I think you can safely assume the judge will not have read your brief, have no idea what your case is about, and it might take a while to get resolved, and when it's over, you will get an unreasoned judgment that doesn't include an opinion explaining what's happening. There are reasons for that, but in the business court, it's the exact opposite. You're going to get a judge who has your case from start to finish. We don't have the problems with the central docket that you have in Austin or San Antonio. You're going to have a judge who writes a reasoned opinion whenever the judge thinks it's important, or for dispositive motions and things like that. If you just ask them to, they'll explain themselves. You're going to have a judge who's selected for expertise in this area. In Texas, we have judges who cover all sorts of different types of matters. Some of them come out of the family court system or something like that, and in more rural counties might wind up hearing some civil matters. That's not going to be an issue in the business court. They have expertise in civil litigation related to business or civil transactions related to business. And so I think we're finding that they're going to be more expertise, a little bit more professionalism with regard to the business matters, and things will go generally better, in my experience, for sophisticated litigants. To share an anecdote, I was representing a Bitcoin miner in a contract dispute with another Bitcoin miner in a rural Texas county. The judge there, and there's just the one, he was, sophisticated, smart guy, hardworking, couldn't criticize him at all. But he had a lot of matters to handle that didn't have anything to do with complex commercial litigation. And so when you sit through 6 or 7 uncontested divorces and some child custody issues before you stand up to tell the judge all about the Federal Arbitration Act, and you say, well, I'm not going to use FAA. I'm going to explain that acronym on the front end. And he was grateful. He's a smart guy. He figured it out. I thought he got to the right answer in the end. But at some level, he actually asked me at one point, hey, have you guys heard about this new business court? I said, yes, Your Honor. He said, this might be a good matter for that court. And we said, well, it would be, Your Honor, but they're not up and running yet. This was a couple of years ago. So I think that it's going to be a good setup for Texas litigators and people who litigate in Texas generally on both the judicial side and the company side. So Justice Farris, I think, mentioned that one of the benefits of the Texas Business Court is it will handle more of those kind of commercial matters that we might care about independent of internal entity claims, right? We want to have judges like this hearing our breach of contract matters, even if all we want are damages and not specific performance, while the Chancery Court is limited to equitable relief. So let's think about a couple of the points of comparison, though, as we kind of shift from the ordinary litigation that I think of to some more of these derivative suits and internal entity claims. One of my favorite innovations I've seen coming out of the Texas legislature on this, I think Rudy mentioned it, is the option for a company to amend its bylaws to create a 3% threshold for derivative suits. So I assume the people in this room know all about this, but the basic background is the ordinary way of controlling a corporation is through its board of directors. Sometimes the law has created exceptions to that and say, well, maybe an individual shareholder can come in and effectively decide that the corporation should be bringing a lawsuit, even if the board of directors doesn't want to. That's a derivative claim. It's a little bit odd, at least to me, and I guess to the Texas legislature, that anybody can do it. You can own one share. The Elon Musk pay package situation, he wasn't a major shareholder. He wasn't actually financially affected by this. He just didn't like Elon Musk, I guess. Well, that's not going to be an issue if your company doesn't want it to be in Texas anymore. I know that Tesla, I think, pretty much immediately amended its bylaws so that it has a 3% threshold. Southwest Airlines did that. There's a case pending right now in the Northern District of Texas, so we won't ask any of our judicial colleagues to comment on it. But there's a case right now where after the time a demand was made on the board, the law took effect. The airline immediately changed its bylaws, imposed this 3% threshold, and then the plaintiff filed the suit. And so it's kind of an interesting setup. We'll see what the court says. I personally think the court's likely to uphold the constitutionality of that 3% threshold. But even if it didn't, it'd be for pretty unique factual reasons related to the plaintiff claiming it's actually unconstitutionally retroactive because it happened after the demand was made, even though it was before the suit was filed. So I think that's an innovation. I think Rudy said maybe Delaware will take that up. I guess we'll see. He said it might actually already be legal in Delaware, and I don't doubt Rudy's legal analysis on it, but it's possible that the good companies of Delaware don't know that yet because it doesn't seem they've taken that up. And so with things like that, and maybe the other example we should go through is the fiduciary duties for controlling shareholders. This has been an issue in Delaware law for a long time. I know many of you have probably litigated it. That if you're a big enough shareholder that you have de facto control, then you may wind up having fiduciary duties owed to your other shareholders, even when you're not acting as a director, you're just acting in your capacity as a shareholder voting on something. That has not traditionally been the rule in Texas. I think there might be a couple of old common law exceptions or something, but generally speaking, that's not a successful claim in Texas court. So with things like this, is it going to lead to Texas overtaking Delaware? Maybe, but this isn't like a first past the post election. You don't have to be in first place to get a lot of benefits from your reform. If Texas can attract more businesses to Texas, that'll be good for Texans. And I think the governor and the political leadership of the state will be well pleased. Whether it, puts that 30% hole in Delaware's budget, well, that would be awful for Delaware. And I think they're not going to take it lying down. So that's why we saw that rush that Rudy described to pass a new law. I think it was SB 21 in Delaware, designed to kind of fight back. They don't want to lose out on that franchise because it's such a huge part of their budget and it would be a huge problem for them to lose. So I think there's going to be more competition, and regardless of who's in first place at the end of the competition, I think it's going to be a more business-friendly environment across the country. So even if you want to be in Delaware, I think you should be encouraging Texas to compete with Delaware along these lines and vice versa. You don't want to have a monopoly situation where Delaware can just be complacent and not care and let their judges go out and say crazy things about going boldly where no one's gone before. So I know that one of the main issues that business leaders thinking about having more litigation in Texas have been worried about is the jury right. Delaware has traditionally not had any possibility of a jury right in its chancery court system. That's where all the big business litigation is. So they don't have to worry about juries. And we all know that in a lot of sophisticated transactions, the companies will want to include waivers of jury rights in the contract to make sure they don't face that kind of uncertainty. We'll see how it goes, but the Texas legislature, although bound by the Texas Constitution, which protects the right to a jury trial, is finding ways to ameliorate that. So in the recent legislative session, they passed a bill that makes it acceptable for corporations to put into their bylaws and governing documents that when you buy shares of stock or just continue to hold shares in that company, you are waiving your right to a jury trial for claims against the company. And so that, I'm sure someone will challenge the constitutionality of that. I expect it will be upheld because both state and federal law have long recognized the ability to waive many constitutional rights, including jury trial rights. So it's not that you're absolutely prohibited from having a jury trial or that the state won't provide a jury trial if it's properly invoked. It's that by entering into this transaction, you have agreed not to assert that right and you'll be held to that. The last point where I think Texas is really making a concerted effort to improve on Delaware law is with regard to the business judgment rule. So one of Delaware's main advantages is it has a large body of case law. I think I read somewhere that the Delaware Chancery Court has existed since the 1790s. The Texas Business Court has existed since 2024, I think. So we don't have that area of precedent built up. So they want to codify more things, make the law clear on the front end at the legislative level, one thing they did was codify the business judgment rule. And they didn't just codify it the way Delaware decisions would if you codified them. It seems like they're really pushing back against these more searching levels of review, like entire fairness and enhanced scrutiny and things like that. So I think we'll see continued competition. It looks like Delaware will be pushing back, and the Texas legislature will probably push back some more, and we'll probably all wind up better off in the end. With that, I'm excited to hear about the Texas Stock Exchange.
Well, thank you, everyone. Thank you, Will. And thank you, Your Honor, for that kind introduction. And thanks to the Federalist Society for having me on this illustrious panel. As you heard, I'm the General Counsel of the Texas Stock Exchange. And you say, well, what the heck is the Texas Stock Exchange? You've never heard of it, or you may have just heard about it on this panel. But it's really the brainchild of Governor Abbott. About 2 years ago, he called a meeting of people that he knew and others knew. And in fact, I attended that first meeting in the governor's office, representing a large retail broker who I worked for at the time. But out of it came the leadership of the Texas Stock Exchange. And over the course of the next 2 years, we raised $250 million from investors around Texas and around the country. And we were the most capitalized entity to ever apply to be a national stock exchange. And so we intend to compete for corporate listings and also to provide a world-class trading platform that will be based in Dallas. Now, we're well on our way. Now, on September 30th, we received our approval by the SEC for our application to be a national stock exchange, the last day before the government shutdown. Can you imagine? You don't think I wasn't pushing like over that weekend. Can you please approve us? But it occurred, and so we're on our way. Now, trading will launch sometime next year in the second quarter. Listings will occur. Probably ETF listings will occur, later, another month or two after that, and then corporate listings will be on our way. But when you step back and you look at today's markets, and a lot of what I'm going to say sounds like an infomercial for Texas Stock Exchange, and it largely is. It's hard to separate from what you do, but the duopoly of listings today, New York and NASDAQ, have not served issuers well. And frankly, the corporate law hasn't served issuers all that well over the years. And so there's, if you look at the number of public companies, the number has fallen 45% in the last 20 years, 45%. And what does that mean? Well, it's true that new ideas, new companies can get their financing from private equity firms. And in fact, private equity firms dwarf public listed companies today. But the fact is, individual investors across America are denied the opportunity to get in at lower levels from these great companies because they're not able to invest. They're not able to meet the standards for private equity investing. That's a problem for the country. And I think we need to focus on that and be able to say, wait a minute, everyone needs the opportunity to grow their assets. And we intend to reverse that trend at the Texas Stock Exchange. We're going to create our listing rules which will be more aligned with issuers. That doesn't mean that our standards for listing are going to be lower. In fact, our rules, as approved by the SEC, set higher standards than, or among the highest in the world. And in fact, 1,400 plus companies that currently trade on NASDAQ in New York wouldn't be eligible to meet our initial listing standards. So it's going to be high quality companies, maybe quite a few Texas companies that are going to come to us because they're fired up about it. But it's going to be fierce competition with the duopoly. They don't take lightly to someone coming into their space to try to challenge where companies go to list. And several other exchanges over the last 10, 15 years have tried to do this. and it failed miserably. But we have kind of a ace up our sleeve. We have Texas legislature and the Texas political body, which is more pro-business, more pro, what can we do to bring companies to Texas? What can we do to promote a stock exchange to make Texas a financial capital of the United States? And that's really the intent. You know, by the way, you may not know this, but like our largest banks, JP Morgan, has more employees in Texas than they do in New York. And these are things, so there's a shift on its way. Now, we heard just a minute ago by Will about the business judgment rule codification, and certainly we think that's an important aspect of what has been done. You know, the debate of whether codification or case law, which is better, it will go on, and there's going to be a real, an interest in citing it. But if you look at it from a corporate perspective, and in the perspective of your directors and officers' insurance costs, there's no question that Texas will, what they've done is going to lower your costs as a public company. And that's just on that rule alone. Now, there's SB 1057, which was a rule that was created to provide limitations on shareholder proposals. Companies can opt to limit and impose ownership limitations on shareholder proposals. Now, again, this is an issue that plagues corporations, public corporations, and that the nuisance proposals cost a lot of money. There was a study in 2020 by the SEC that the average shareholder proposal costs the company $100,000. Legal review, proxy preparers, and anything, like shareholder outreach. These things cost money. Well, I could promise you today, if it was $100,000 in 2020, it's $300,000 or more now. And so that's only going to continue. So Texas has said, wait, whoa, let's slow down. And if a corporation has equity securities registered under Section 12B of the 34 Act, is listed on a national stock exchange, and has either headquarters, what they call it principal place of business, but headquarters in Texas, or, and you might see where we had some influence, a listing on a Texas-based stock exchange approved by the State Securities Commission. So, which, by the way, we have been approved by the State Securities Commission. So, so you can see, we're offering opportunities to opt into a measure to limit shareholder proposals by either headquartering in Texas or by being listed on the Texas Stock Exchange. And again, there will be cost savings by doing this. Now, this rule, which allows the company to require $1 million in shareholder value or 3% of outstanding shares, is now law, and it will lead, we believe, to another factor in allowing companies to come to Texas. Now, of course, that standard is different than what exists today in Delaware. There's no minimum threshold for shareholder proposals in Delaware. There's the SEC rule, Rule 14A8, provides that you have to hold the securities for 1 year, $2,000 in value, or 1% of the outstanding shares, much lower threshold. And there was always the thought that, well, that's a ceiling. You can't go above that. No, that's not the case. The SEC Chairman Atkins recently reiterated the SEC position that it's a default standard, that if state law or corporate governance documents don't address ownership thresholds, then you have to apply what the SEC 14A8. But otherwise, you're free to make a higher standard, and that's what Texas has done. So another issue that has come up that Texas has dealt with is proxy advisor firms. Now, it's SB 2337, and that rule set that begins to regulate proxy advisors. Everyone, if you have clients who are public companies, and I worked for a public company before, proxy advisor recommendations are a nightmare because they're rarely accurate and they're often ideologically driven. And so the Texas law, boiled down, just requires disclosure by the proxy advisors if their recommendations are non-financial, or take into consideration non-financial factors. So again, this is something that the proxy advisors obviously don't really like. In fact, ISS and Glass Lewis have filed suit against the state of Texas to challenge the constitutionality of this statute. Now, the Texas Stock Exchange, we believe in this statute, and at least I certainly believe in it, having dealt with them, and so we've intervened in that case and are going to be supporting the state in the litigation that goes forward. So I think, just quickly, these things are what Texas is doing to try to promote not only business and finance, but to bring companies to a state that really wants to, encourage that reincorporation, as well as possibly listing on the Texas Stock Exchange. And I'll just leave you with one quote that I think sums it up. This is by Chairman Atkins again at the SEC. He said that, just a couple weeks ago, the costs of being a public company, coupled with the politicization of shareholder meetings and the ever-present specter of costly, frivolous litigation, have negatively impacted the vibrancy of our capital markets. Well, that's a pretty damning statement, and that's what Texas is out to change. Thank you.
So, thank you very much. Before I start, I'd like to thank the Federalist Society for hosting what's a timely panel, and Judge Ho for moderating it. I'd like to thank my fellow panelists because it's a great pleasure to be here. I'm going to be brief, but I'm also going to provide a slightly more unusual or heretical perspective on Delaware and this competition than probably you heard from Rudy. First of all, he's right. The debates on Delaware's leading role on the competition for corporate charters comes in cycles. In 2007, I published an article with former Chancellor William Chandler that rebutted some academics who were saying that Delaware's continuing success was a mystery. And I knew that we were due for another round of this discussion when that 2007 article was cited in the expert report that was attached to Tesla's proxy when Tesla was reincorporating into Texas. And Tesla presented it as the minority view that Delaware corporate law was determinate and predictable, or at least no less so than anywhere else. Well, in all that time, I haven't changed my opinion. Delaware law remains more predictable than any other jurisdiction, and in all likelihood, I think Delaware will remain the leading jurisdiction for incorporation, at least for the rest of this decade. But I also suspect we're going to be having this conversation within the next 5 or 10 years again. And to explain why, I want to consider two questions. First, why is the debate occurring now? And second, can we say that Delaware's recent legal reforms have ended the Dexit debate? Dexit, by the way, Delaware exit. I realized nobody had actually, explained that term. So first, why are we having the conversation now? What's changed? Because the Texas Business Court really isn't the state's first innovation in corporate law. In fact, there was a 2013 Texas appellate case that was one of the inspirations for me starting my own firm that represents stockholder objectors in the state of Delaware. See, for almost 2 decades, Texas has had an unusual rule. In class actions, if the class recovers anything but cash, the attorneys are to be paid in the same currency. Ted Frank in the Center for Class Action Fairness, which is known to many of you here, successfully argued in a Texas appellate court that under that rule, attorneys who secure only supplemental disclosures in merger settlements get paid in supplemental disclosures, not cash. That largely ended a particularly pernicious practice, what were called merger tax settlements, 3 years before Delaware reached its own solution to the problem. And that inspired some attorneys, including me, to try to bring these kind of cases in Delaware. But if the competition isn't new, I think its nature has changed. Earlier business courts, for instance, North Carolina's, largely imitated Delaware's strengths. Today, as you heard earlier from Justice Farris, Texas and Nevada are similarly imitating the Court of Chancery in some ways, but they're also differentiating themselves. Take one of Delaware's undeniable strengths, what I call the gods at war cases. And I steal that name from Professor Steven Davidoff at UCLA. These lawsuits, usually between large business entities, nary a contingency attorney in sight, can be handled in Delaware at a pace unmatched anywhere else. An example would be the Twitter versus Musk case, where Elon Musk offered to buy Twitter, tried to back out, and ended up closing after a few months of very hard-fought, very expedited litigation. Now, I agree with Rudy that speed in that kind of case is Delaware's superpower, and it hasn't been replicated yet. But one of the interesting things about Texas is how much of the debate on the formation of its business court is public. I've often joked that I'm a Delaware attorney. I know more about how the Texas business court's rules are made than I do about Delaware's. And you can see this in public online discussions where Texans are discussing how they need to create a cadre of expert court reporters or have a group of expert law clerks for the business court. Other non-obvious parts of the ecosystem necessary for lightning-fast litigation. Frankly, I don't know if they're going to reach the right answers, but I can tell you they're asking the right questions. So where is Texas differentiating? And one significant area here is fees. In class actions, Texas, as Rudy mentioned earlier, imposes a fee cap of 4 times an attorney's lodestar. And for those who aren't familiar with that term, a lodestar is the amount of hours that a firm or an attorney dedicates to a case multiplied by their hourly rate. At a very high level, what a lodestar cap like that does is limits the riskiness of the cases that can be brought. Simplifying the math slightly, a contingency attorney who is subject to a 4x fee cap will only want to bring cases with a 1 in 4 chance of success. If the fee cap were higher, say 10x, then that attorney will be willing to take riskier 1 in 10 chance cases, and those could be profitable. Delaware has no lodestar cap. The highest lodestar multiple award in a case called America's Mining was 66x. Now think about that for a moment. An attorney who puts a person-year of effort into that case can retire with a lifetime's pay. Now that case is very much an outlier, but 10, 15, 25x multipliers are not uncommon, and they've become more common in the last decade. And that's why I think we're seeing this controversy now. Yes, there have been a series of recent cases that surprised the market, but the occurrence of surprising cases shouldn't have themselves been surprising. When a very experienced, skilled plaintiff's bar can reap life-changing rewards by finding new wrinkles in corporate jurisprudence, the number of those cases will multiply. And if only a fraction of those cases end up to be surprises, you're still going to see more surprising cases. And as I said in 2007, Delaware law remains more predictable than any other state's corporate law, but it's much more rigorously and more commonly tested. And that testing, I think, can have high costs for corporations, particularly for innovators that may run into more murky legal areas more often. At a high level, what this debate that's going on here, I think, is really about is what is the value of corporate governance? What is the supply and demand that is demanded by the market? And in a sense, are Texas and Nevada competing to provide a same or at least similar, if less tested product, but at a lower price? And that's why, if I'm right, I don't think that the Texas debate is over. There were a flurry of very large companies that left at the beginning of the year. Dropbox, Roblox, and Simon Property Group among them. But recently, the levers have slowed to a trickle, and it's mostly micro-cap and nano-cap firms. And I think it's tempting to think that, Dexit was a myth, or the legal reforms that Delaware enacted earlier this year stemmed the problem, and we're going to go back to the status quo. I think that's probably premature. Because as Rudy said, the Delaware General Assembly asked the Corporation Law Council to give recommendations on attorney's fees this year. But we haven't actually seen a report. There's nothing public that's happened. And I'm a little more skeptical than Rudy about whether we're actually going to see reform. And without that, I think even though Delaware will probably maintain its dominance, we're going to end up having this debate again. As I said, they're cyclical. They tend to come up when there's controversy over the value of litigation. After the Court of Chancery constrained merger tax litigation in the 2010s, plaintiffs started bringing these entire fairness cases that Rudy talked about, often against controlling stockholders. SB 21 gives some protection against controlling stockholders. But that just, leads to the question, what's the next thing? There are still hundreds of very smart, very skilled attorneys who know that if they find the next batch of lucrative cases, there can be life-altering compensation available. And so while I'm mindful of the old saw that it's difficult to make predictions, especially about the future, I think it's a safe bet that we're going to see some kind of new controversial litigation emerge in the next few years. Not because Delaware law is less predictable. I actually think that's a wrong diagnosis. But because there's more money to be made testing it where it is indeterminate. Next time, though, and this is what worries me, states like Texas and Nevada are going to be further along in their reforms and possibly better placed to react more nimbly. But the good news, at least for me, is that if I'm right, Federalist Society can have another one of these panels in 5 to 10 years, and they can invite us back. So I'm going to ask you all to say really nice things on the CLE forms, and for which, again, I'm going to thank the Federalist Society and Judge Ho for moderating.
Anyone on the panel want to respond or engage with something you've heard today?
Yes. So Anthony, I sent some emails while you were talking, and you were not allowed back in the state. So look, I'd say a couple things. So I think the spirit of what everyone said I agree with. I like a lot of the things that Texas is doing. On the Texas amendments, let me just say this. I think they're well-meaning, but I think they were rushed. I think they're a little bit one-sided, and I think they have a little bit of a Frankenstein sort of feel to them. So when we talk about the business judgment rule, no bigger fan than me of the business judgment rule, but the way Texas codified it, it basically wrote out the duty of loyalty entirely. So good luck when you have a venture capital firm or a private equity firm that gets totally screwed in Texas and has no recourse. The thing you need on these rules is you need balance. And the reason that balance actually benefits everyone economically is because obviously if investors feel protected, they're going to part with their capital on more favorable terms, and that actually is what helps all the companies. On the jury trial waivers, I seem to hear some wavering on whether or not they're constitutional, so we'll see what happens there. 3% threshold, I think, has also been constitutionally challenged, so we'll see what happens there. And these are just little examples of what happens when you're flying the plane and you're trying to build the plane while you're flying it, right? So I do think there are things that are going to have to get worked out, even though I think the spirit of some of the things that Texas is doing is great. The other thing I heard I just wanted to respond to briefly is that it was some sort of a knock that the Court of Chancery just has equitable jurisdiction and jurisdiction to hear corporate cases. We actually have two specialized courts in Delaware, and I want to be clear on this. The Complex Commercial Division of the Superior Court is the second best state court in the country. And I will say that when I first started, when I came to Delaware, I came to Delaware 20 years ago. I was working in New York at the time, and luckily I got out of New York. New York had a new business court, Complex Commercial Division. It was supposed to compete with Delaware. Since then, more companies have put in Delaware Superior Court Complex Commercial Division because it's the best place to have your contract disputes heard. It just is, and that's that. The other thing is when I did start in Delaware, that was just when Nevada had copied our code, and that was supposed to be the new frontier back then. That was 20 years ago. Some companies have moved there. It's not a lot. They all tend to be of the same type and tend to be controlled. So I just want to say what Delaware will never do is Delaware will never engage in a perceived race to the bottom. We're not going to do what's fashionable. That's part of we don't face the normal political pressure we're always going to balance the interests of all of our constituents, because that is what actually makes Delaware companies stronger. That's what makes our corporate law stronger, and that's what we're going to do. I think Texas is doing a lot of things right, but I think they're rushing a little bit into a one-sided direction, and I think they may come to regret that as we go forward over the next few years.
Hey, Rudy, can I ask you a question? The SB 21 that was adopted by Delaware seems to, well, the claim is it was rushed. And in fact, there was a hearing yesterday before the Supreme Court on its validity. How do you think that's going to come out?
Sure. I will humbly bet my mortgage that there is a 0% chance the Delaware Supreme Court will find that that's unconstitutional. In terms of that being rushed, I would say that statute had been thought about for a long time. It came out of an article that was written by Leo Strine, the former Supreme Court Chief Justice, Justice Jack Jacobs, and a Professor Larry Hammermesh, that they had written 2 years beforehand. So that statute had been in the work for a long time. So I understand the news likes to say it was, I read somewhere that my firm wrote it over Valentine's Day weekend. I can assure you we did not do that. I was being very nice to my wife on Valentine's Day weekend, and we were not writing a corporate statute from scratch. So I do take your point, but in reality, I don't think that was rushed. And by the way, I do actually support what you're doing to make IPOs great again. I think that's a good thing. I think there are lots of reasons that IPOs have fallen off, including private equity, but some of the things you're doing on the Texas Stock Exchange I think are good.
Anyone else on the panel?
I'm happy to keep going, but I think we may have run into our time.
Okay, well, we do have a few minutes for questions from the audience. Why don't we start with the gentleman over here?
Hi, Kevin Douglas, question for Mr. Brown. I'm curious as to whether or not you think that the Texas Stock Exchange has to be subject to SEC rules in order to get done whatever they're trying to get done. And in part, what motivates the question is, one, knowing that to some degree, some part of Texas's electrical grid is somehow exempted from certain kinds of federal regulations that the rest of the country's electrical grid has to do with, or some type of FERC interaction. And then the second, sorry, for those who couldn't hear me, I'm curious about your thoughts on the degree to which the stock exchange actually has to be regulated by the Securities and Exchange Commission, in part because I know that some aspects of Texas's either electrical grid or other energy regulations has been exempted in some way by confining some part of what it does to Texas and very close states. And another motivation in the question is knowing that these stock exchanges to me seem less like a duopoly and more like a monopoly, to the extent that SEC rules have to, the Securities and Exchange Commission has to approve all of their rules. It seems like they're not really that different from one another, because the SEC comes in and it kind of says you better do this. And to me, I know the rule, they're self-regulatory organizations.
So let's go ahead and get the chance for the answer.
Okay. I would love the idea that we would not be subject to the SEC's jurisdiction and subject to their rules. And in fact, you're correct. There is a thought that if you created an intrastate exchange that did not do business outside the state, you could swear off SEC regulation. Fortunately, you can't do that, because how do you control the internet? Where do your orders come from? If the orders come from outside state, you are subject to interstate commerce, you're subject to the SEC. So this has been talked about. We have ideas about maybe we would form some kind of interstate operation, but otherwise, exchange world is the most heavily regulated industry that you can imagine, and it took us 18 months to complete our application and get approval. So, but I love the thought.
Gentleman back there.
Can you hear me? Question for Will. One of the traditional advantages of doing a merger involving a Delaware company versus a non-Delaware company is just the ease of working with the Secretary of State in terms of pre-clearing a certificate of merger or an amendment to a charter, and also just in terms of wires. The Secretary of State in Delaware, they're open, I think, as early as 8 a.m. Eastern, so that works very nicely in terms of getting confirmation of clearance for a merger filing and then, getting wires across. That sometimes is harder with jurisdictions that are, in Central Coast time or Pacific time. What do you have any visibility into what, if anything, is being done in Texas in particular to kind of rectify for that gap? Because at least in my experience, the several times I've dealt with this with non-Delaware jurisdictions, not necessarily Texas, it's been a bit awkward coordinating the time zones, and sometimes there isn't as much responsiveness from the Secretary of State's office. So curious if, in the context of Texas, you've got any visibility into what's being done there.
Yeah, I think I'll have to confess some level of general ignorance, not being a transactional attorney myself. What I can tell you is that the Secretary of State's office will often take political guidance from the governor's office, and that means they're going to be fully on board with doing whatever needs to be done to kind of make this political project work. So if people like you were telling them that we need someone to answer the phone at 7 a.m. on a Saturday or whatever to make sure that our mergers can get done in a timely and efficient way, I feel confident they will find a way to make that happen. I used to represent the Secretary of State some when I was in Texas government, and their general counsel is a very reasonable man, and I'm sure that they will find a way to make that happen.
I think we have time for one more question from the gentleman there.
Thank you. So I wanted to ask a question about from Delaware representatives. One of the issues that I see as a difference between Texas and Delaware is, while Delaware has the vast majority of corporations, Fortune 500 corporations that are incorporated in the state, I'm not aware of any of them that actually are in the state. And there is a significant issue about the law of Delaware governing the operations of companies that don't touch Delaware other than your office where they have their incorporation. And I'm curious as to your thoughts about that disconnect. And Delaware is a small state that's not really representative, unlike Texas, where a lot of the companies will be located.
Yeah, so look, I actually view that as a strength, and I think I said before, that's one of the reasons you can't get hometowned in Delaware. And, if you think about Nevada, for example, is their corporation franchise more important, or is their gambling industry more important? In Delaware, you're not going to get hometowned if you're from one part of Delaware and you're being sued in another part of Delaware. You're not going to get hometowned if you're company A versus beloved company B. Even the DuPont company, you're not going to get hometowned on. So I actually view that as a strength. I think the reason that Delaware has been trusted is precisely because we don't have those other interests that come into the corporate law, and that the corporate law is the interest for the state. And I actually view that as a strength.
So I'm going to agree with Rudy, not just because I'd like to get back into my state, but I would put a little wrinkle on one of the things he said, because I was on a panel like this last year when this Dexit debate was starting, and it was in Nevada. And, he just asked a question, well, can you get hometowned in Delaware? Is Nevada going to do this? We were at the Wynn. And there are a couple of academics who have criticized Nevada by saying you're never, ever going to be able to win a plaintiff's case there. Well, there was a plaintiff's case one there. It was a derivative lawsuit, ended up with, it was a multi-million, I think it was $30 million settlement. And it was against Steve Wynn, which made for a very interesting conference because we kept on talking about how Steve Wynn had ended up having to pay for this derivative settlement in the Wynn Hotel. I think it's very definitely an advantage. I honestly, the answer to the question is you have to incorporate somewhere. I'm not sure that, if you were to incorporate in Texas, just because you're headquartered there, it necessarily gives any kind of advantage from a federalism point of view. And I think you are maybe asking a little more theoretical question. Some states, unless we have a federal chartering system, which I think would be the worst of all possible worlds, you're going to be incorporated in some state, wherever your headquarters are, and the companies choose where they're going to incorporate. So honestly, I don't think it's a big differentiating factor, even though, as Rudy said, you're not going to get hometowned in Delaware.
Great. So quick programming note, the next breakout panels start at 3:45 p.m. We've got a networking break until then. So we are adjourned, but first, please join me in thanking our panel.